Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning. This is Jim Santel, and yes, it is Saturday, July 1st, the first day of the new month. A very special broadcast this morning on Morning Cannolis. As always, it's our weekly review, our analysis, our discussion of those most important news events, those occurrences and stories in law, government, and yes, the aspiration for justice in America, especially relevant this morning as we spend all of our 2 hours together talking about, once again, the United States Supreme Court. We're coming to you this morning, as always, from the studios of WAUK Radio in downtown Waukesha here in beautiful Wisconsin. But we're broadcasting throughout the listening regions of civic media in our state. Those include WMDX in Madison, WAUK right here in Waukesha, WRJN in Racine, WFHR in Wisconsin Rapids, WXCO in Wausau, WBZH in Haywood, WLAK in Amory, WISS in Oshkosh, WGBW in Green Bay, WRCE in Richland Center, WLCS in La Crosse, and yes, from a venue at which I recently did appear in one of the broadcasts of civic media, W228EP The Tap in Eau Claire, Wisconsin, welcoming guests, listeners, and participants in our discussion from throughout the state of Wisconsin. Thank you for joining me this morning on Morning Cannolis. As always, especially this morning, we're going to be taking your calls at 844-967-2789. That number again, 844-967-2789. Taking those calls, inviting those calls through my professional, my engaging, my always effective producer, Anya, who's with me in the studios this morning. Looking forward to hearing from you. Your questions, especially this morning, your inquiries, your comments, your observations about the topics of these days. And yes, the topic of these days is the United States Supreme Court, especially focused this morning on 4 major decisions issued by our high court just in the past 48 hours or so. Even so, our discussion this morning always organized around 3 basic questions. What happened? What are the facts? What do we know about these cases in particular? Why? Why are these decisions important to America, not only presently, but in the future generations yet to come? Why are they relevant? What's material about them? And then the all-important question that we sometimes leave unanswered in America: what do we do about this? What do we do going forward to address concerns and issues that we have about decisions of the Supreme Court, those that are affirming of the humanity that is our nation, and those that tend to send us back? A lot of discussion this morning about the second of those categories, not excluding the first. Last week, we began the first of this 3-arc series of broadcasts in which we're going to be focusing upon the United States Supreme Court. As you know, listeners of this program know well that this is the period of time every single year when our United States Supreme Court, 9 members of our highest court in the land, issue their so-called high-ticket items, the big decisions of the past term. This is the 22-23 term. Last week, we talked about 4 of those major cases, very different in temperament, in tone, in content than what we're going to be talking about this morning. We talked last week about this major case affirming the legislatively supported authority, the discretion, the ability of the Secretary of Homeland Security to operate his agency as he chooses, exercising discretion on behalf of the people of America to ensure that our immigration laws are applied fairly and evenly, focusing on deportations just as to those people who pose the greatest threat to our national security, our safety, our security generally in our communities. A challenge to that pushed back by the United States Supreme Court that said in a major decision that, yes, indeed, the Secretary of Homeland Security does have the authority given to him by the Congress to ensure that our immigration laws are supported equitably and decently, but setting priorities given a circumstance of limited resources, focusing on those people who pose the greatest threats to our safety and security, and affirmation of executive branch authority, something we did not see this past week, as we will get to in just a moment or so. A second case last week we talked about of confirming the long-settled meaning and import of the Voting Rights Act. The Voting Rights Act taking a fair number of hits recently by the Supreme Court, clipping its wings in terms of enforcement through the U.S. Department of Justice and even in other mechanisms. Recently, in this term, an affirmation of the Voting Rights Act in a major case that affirmed the right of Americans to vote regardless of color, affirming the capacity of our government to ensure that gerrymandered districts do not disenfranchise people of color. A major case that, again, reestablishes, as if we need to have that reestablished, apparently we do, that the Voting Rights Act means what it says and says what it means from 1965 to this day. A major case that, again, kept in place one of the major enforcement mechanisms of that all-important law. A third case last week upholding the constitutionality of the Indian Child Welfare Act, sometimes called ICWA, the law that requires that state court judges, when they are addressing issues related to adoption, placement, custody, those kinds of things involving our youngest citizens, youth, that if you have before you as a judge, you are obliged under the law to give consideration to the Native American heritage of that young person. And when making decisions about placement, about custody, and those kinds of things, attempting as best you possibly can to place that child in an environment, in a family that would support that heritage, this law as a part of ensuring that our heritage of indigenous populations in our nation is preserved for the future and also for the present. An affirmation upholding that law by our United States Supreme Court, the third of the cases we talked about last week. And the fourth one, validating the right of nursing home patients to sue if, in fact, they have been the victims of maltreatment, mistreatment by their health care providers. A major case coming out of the Seventh Circuit and Indiana in particular that, again, affirmed the right under Medicaid to ensure that families of people and individuals themselves who are the victims of mistreatment, healthcare mistreatment, have a right to sue. Sounds like a very narrow kind of decision, but actually very important to establishing, once again, that Medicaid remains strong. Also, Medicare derivatively coming out of that lawsuit. All those cases affirming and ensuring that Americans have access to all the good things established by and promoted by our Constitution and indeed by the Declaration of Independence that we celebrate in this coming weekend. This week we're going to talk about four other cases that go in many ways in a different direction, that send us backwards in a way that is concerning, troubling, highly disconcerting for all of us who look forward to an America that is inclusive and contemplates equality and equity for all people. We're going to get to that in just a moment. We are celebrating in this coming weekend the 4th of July, the 247th anniversary of the Declaration of Independence, signed on this day, and establishing, again, all those fundamental rights that are implicit, if not explicit, in the cases we talked about last week, and implicitly recognized, if not completely advanced, by the United States Supreme Court in at least three of the four cases we're going to talk about this week. It is also the 234th anniversary in September of our U.S. Constitution, recognized on Constitution Day. Again, 234 years of that. In past broadcasts, I have routinely talked about things that have happened on this day in history, returning to that tradition today for recognition, observance, a solemn observance of something that happened a year ago when we celebrated the 4th of July here in America, July 4th, 2022. You recall well, a young man used an assault weapon and a high-capacity magazine to fire about 70 rounds into around a group of parade-goers in Highland Park, Illinois. He killed 11 people. He injured many, many others, including a very young man named Cooper Roberts, who was paralyzed from the waist down. Stories this weekend, a year later, about his resilience, even in the wake of this horrific tragedy visited upon him, his family, and all of us in America, reminding us again that even on a day when we should be celebrating our liberty and our joy in this nation, it is often, regrettably, also marred, is pockmarked by this kind of horrific violence that we saw a year ago in Highland Park. what do we do about that kind of thing? What do we do? How do we respond to that kind of activity? Well, again, as we have talked about on this program, lots of things that can be done by our state legislature here in Wisconsin, by our federal legislature in Washington, D.C. We've talked about those remedies. They're available to us. We know they work because of experience with them. And we know as well that they should, in fact, be passed to ensure that the things that happened in Highland Park a year ago do not happen again. We think again about the other things that can be done. We know that coming out of Highland Park, two significant sets of things. We're going to talk today a lot about litigation, about cases, about court work that results in decisions that do in fact impact us positively and sometimes also negatively. Two big packages of litigation coming out of the Highland Park horror that terror visited upon us and that community in particular a year ago. We know that the young man, the 21-year-old, the shooter, has in fact been charged with 117 different charges, including 21 counts of first-degree murder. We expect that, we anticipate that when you engage in that kind of violent behavior in America, using firearms to disrupt not only a celebration of our nation, but also the peace and security that we should expect every day, every time we go out into public. We also know, however, coming out of that piece of horror in Highland Park, a couple of other things happened. The government is also suing, has also brought charges against the father in Lake County, 7 counts of reckless endangerment, reckless behavior, for his behavior in signing off on an application for this firearm that his son acquired under the Illinois firearm ID law that was required before one can buy a firearm, charging him with this reckless conduct in doing that kind of thing, sending the message that you too, even if you're not the shooter, are responsible in part for this kind of behavior. And we also know that there is a lawsuit against Smith & Wesson, the maker of the assault weapon that was used in that violent conduct, alleging that they themselves, the makers of this gun, were involved in this horrific assault by virtue of establishing and promoting a campaign for this M&P 15, this assault rifle that was used at the time, specifically targeting youth, that promoted this kind of thing among youth who would be attracted to this weapon. All that kind of thing, that litigation, another thing that can be done and is being pursued today to address this horrific problem in America. And when we come back, some final thoughts about 4th of July in the wake of the Supreme Court decisions coming up this coming hour and next hour, a review of our Supreme Court. Stay with us for that discussion.
Taking it to the street. We'll discuss it further. Oh, no. Taking it. Hey, yeah. Taking it to the street. No more need for running. No more need for hiding.
And we are back here on Morning Cannolis, a discussion this morning of our United States Supreme Court and decisions it has made historically and very recently that affect who we are as a nation, how we live together, and the challenges that we face. Many of those challenges much on the agenda of our discussion here this morning. Our broadcast coming to you from Waukesha, always taking your phone calls at 844-967-2789. Right before the break, talking about the fact that we're also observing in the days just ahead the 247th anniversary of our nation, recognizing, too, that our Constitution turns 234 years old in just a few short weeks as well. And it's out of that Constitution that much of our discussion this morning evolves and devolves in some ways, language of our Constitution and its interpretation. As we think about what happened in Highland Park a year ago, this mass shooting involving deaths of fellow citizens, fellow Americans, injuries to many, many more, and the consequences of that, the things we can do to address gun violence in America, which we know, including those pieces of criminal and civil litigation that I talked about right before the break. Also recognizing that there is a Supreme Court connection, of course, to firearms as well. Many, many years ago, establishing for the first time in our nation's history that under the Second Amendment, a decision issued by Antonin Scalia, that the Second Amendment does provide for all Americans the right to protection in the home by the use of a firearm, a decision never before issued by any Supreme Court, finding that the language of the Second Amendment that talks about a well-regulated militia actually establishes a personal right to ownership, an individual right to ownership in the home to protect you from intrusions or to ensure your self-defense. That position expanded by the Supreme Court just a short year ago, days before the shooting in Highland Park in a case called Bruin, expanding that so-called constitutional right under the Second Amendment to include your capacity, your authorization to carry firearms in the public domain, outside of the home, expanding what Antonin Scalia had said, a decision issued by Clarence Thomas on behalf of the majority in June of last year, further expanding firearms rights in our nation at a time when this great, profound healthcare problem, this medical problem, this social problem, this cultural problem continues to beset us without any clear end in sight. Bruin is the name of that case that was decided just a year or so ago, expanding under the Second Amendment the rights of Americans to carry firearms in public. And so appropriate this morning to talk again about the impact of the things that the United States Supreme Court does on the day-to-day operation of our lives, the ways in which we engage in each other. Let us start down that road now and talk about four major cases that have been issued just in the past 48 to 50 hours or so. Three of those highly, highly controversial and drawing the ire not only on the Supreme Court bench between majority and minority voices there. We'll talk a lot about that. Be doing a lot of readings this morning from what the Supreme Court justices said from their texts, said from their mouths during this past week or so. Beginning with a case in which the Supreme Court sided with a postal carrier who refused to work on the Sabbath. This case, unlike the others, unlike the three other cases we're going to be spending most of our time talking about this morning, this initial case 9-0, a unanimous decision by our United States Supreme Court, including support not only by the so-called conservatives, the so-called liberals, some appellations which I bristle sometimes at because not always accurate in terms of describing how our Supreme Court justices approach decisions. But in this case, 9-0, all of them agreeing. On Thursday, our Supreme Court broadened protections undeniably for religious workers in this case that involved a mail carrier for the U.S. Postal Service who refused to work on the Sabbath. In this unanimous decision, 9-0, all the justices rejected a certain test that had been in place for many, many years up until this past week that had long been used to determine what accommodations an employer had to make for religious workers and what kinds of things an employer was obliged to do to address the specific requests of people of faith in the employment setting. Significantly, this decision issued just a couple of days ago, was not a ruling on the merits of the case itself. They did not say that this worker is entitled to those accommodations. They sent it back to the trial court, back to the lower court for decision on that, for a trial on the merits under a new standard. And that's the reason why all 9 members of the Supreme Court agreed to this. A new standard that established the circumstances, the legal predicate, if you will, for the circumstances under which an employer, public employer, private employer, is obliged to accommodate the specific religious requests of an employer. So writing for the court, Justice Scalia said that the case gave it the first opportunity, he said, in nearly 50 years, and that's right, to explain the nuances of how workplaces have to adapt to religious requests by the employees who are out there. For an employer to deny an employee's request for religious accommodation, Justice Alito wrote, again on behalf of 9 agreeing justices, and here we go, here's the new standard, that employer must show that the burden of granting an accommodation would result in, this is the big language coming out of this case, would result in a substantially increased cost assessment, substantial increased costs in relation to the conduct of the business. In other words, if in fact that accommodation is extended and granted to the employee, that has to be done unless it can be shown that there's a substantial, a significant, a great increase, a dramatic impact upon the very operation of the business itself. That decision obviously could affect countless workplaces out there, could require many employers to make some substantial changes to accommodate those religious workers in our midst. It's the latest, obviously, in a series of rulings, and the Supreme Court has addressed religion during the course of the past terms, including just last term. When we come back, I'm going to tell you a little bit more about those past cases and then come back to this important case having to do with religious accommodations in the workplace, why it's important, and why it's important for all members of the Supreme Court not only to support this, but to understand how this will, in fact, encourage the possibility of religious accommodations in our employment settings. Stay with us for that further discussion about this case and three others here on Morning Cannolis.
And I say, brother, help me please. But he winds up knocking me.
And we are back in this, our first hour of Morning Cannolis, this very special broadcast, one of three broadcasts in this time of year talking about recent decisions of the U.S. Supreme Court. This morning, focusing on four of those. And we're talking about right now involves a postal worker. We'll be chatting in this hour and certainly into the next hour about three other cases so that you can write this down, anticipating your phone calls, your comments, your questions. We'll talk about that case in which the Supreme Court also rejected affirmative action programs at Harvard and UNC and presumably other universities and colleges around the nation. Supreme Court also rejected the president's student loan forgiveness plan just this past week. And finally, it backed a web designer who was opposed to same-sex marriage. We'll talk about that case as well and its impact, along with the others, upon our nation. Right now, again, chatting about this case involving a postal worker. The case itself is Groff versus DeJoy. The case itself, again, important because it establishes a new standard embraced by all members of the Supreme Court for addressing the circumstances under which employers are now obliged to accommodate the religious requests, situations, and tenets of faith by employees. Mr. Groff had sued under Title VII of the Civil Rights Act. We've talked a lot about that on this broadcast. That's a federal law that requires employers to reasonably accommodate workers' religious practices so long as they can do so without undue hardship to the company's business. That's the language of the statute. And a 1977 precedent called Trans World Airlines versus Hardison, that was the precedent until just this past week, sort of stood in the way of this litigation going forward. That earlier decision said that employers need not accommodate workers, religious workers, including people like Mr. Groff. They do not have to accommodate them if the effort imposed more than a trifling, or in language that lawyers love and other students of Latin love, de minimis, D-E-M-I-N-I-M-I-S, de minimis standard, a low levels burden on their businesses. That was the standard up until just this past week. Lower courts had ruled against Mr. Groff, and a three-judge panel of the U.S. Court of Appeals in the Third Circuit in Philadelphia said that accepting Groff from working on Sundays caused more than a de minimis cost to the U.S. Postal Service because it actually imposed on his employees disrupted the workplace and did other things with respect to workflow that, in fact, were more than de minimis. It diminished workplace morale, employee morale, among other co-workers, said the lower court. In a dissent in that case, a judge had said that the majority renders any burden on employees sufficient to establish undue hardship, effectively subjecting Title VII religious accommodation in a heckler's veto by disgruntled employees. A lot to unpack there. The upshot of it is that the Supreme Court, our United States Supreme Court, today embraced that dissenting opinion in the lower court and said, yes, indeed, the standard needs to be higher. The standard now will be focusing upon this higher standard of substantial increased costs that need to be identified as a basis for denying an accommodation. A case that, again, is important not only for Mr. Groff. He identifies himself as an evangelical Christian, but frankly, people of all faiths out there, Jewish, Christian, Hindu, Buddhist, Sikh, Islamic, all people of all religions out there who are interested in not only good and decent employment, which all Americans presumably are, but also want to do that in a way that is not inconsistent with their faith, their tenets, and an awful lot of religious organizations and others beyond the faith communities have embraced this particular decision as saying, yes, it updates the standards, ensure that we can, in fact, have good employment. We can be productive in America. Companies can thrive in America by also ensuring that accommodations are made to people of all faiths, and not just those who may purport to ally themselves, for example, with Mr. Groff as evangelical Christians across the board. This litigation and the standard that established by the Supreme Court just this past week, inspiring those future claims, those future pieces of litigation. Again, the case does not result in an automatic win for Mr. Groff. The Postal Service has said we can meet that standard as well, that because of the request being made, the Postal Service maintains when this case goes to trial, they will show that they can in fact prove that this would have a substantial increased cost upon the operation of this particular postal entity, this venue in particular. We will wait and see. But once again, a major case involving religious accommodation. The Supreme Court, as you know, in recent years has focused a lot on religion, recently ruling that a high school football coach had a constitutional right to pray at the 50-yard line if the team's games, very controversial in terms of religious liberties under the First Amendment. State programs supporting private schools in Maine and Montana must include religious ones as well. That just coming out of last couple of Supreme Court terms. That a Catholic social services agency in Philadelphia could in fact defy some city rules and decline to work with same-sex couples who apply to take in foster children. And that the Trump administration could allow employers with religious objections to deny contraception coverage to female workers. All kinds of things the Supreme Court has done in this religious area. This case from this past term, just this past week, probably somewhat less controversial. Again, as a sign of that, all 9 members of the Supreme Court concur in that. It nonetheless does focus the court's attention once again on its interest in religious cases. We anticipate more of that in the 2022, 2023, 2024 term coming up in the months and the years just ahead. There are 3 other cases that were also issued to great notoriety this past week, just the past couple of days. Let us now turn our attention to those. Unlike the 9-0 position taken by the Supreme Court in Groff versus DeJoy, these other cases highly split, highly antagonistic among the Supreme Court justices, both in writing and on the bench. We saw some things this past week we have not seen before, which is the articulation of dissents by some of the dissenting members of our court in very bitter and appropriately bitter language about what the Supreme Court is doing in these various areas involving, once again, affirmative action, student loan forgiveness, and yes, LGBT rights and prerogatives in America. Let's take each one of those up in line. We are, again, taking your phone calls, your questions, and your inquiries about these cases as I go through a greater, deeper dive into these next 3 cases to understand what this is all about and interpreting for you, giving you some perspective of my own about what these cases mean. The overreaching theme that I see in each of them is our fundamental difference among members of our Supreme Court in 2 major areas. One of those major areas is, what is our nation all about? Who are we today? We have got in each one of these cases, especially the cases involving affirmative action and the student loan forgiveness program, certainly the LGBT case as well. We've got a misunderstanding among what I would offer to be the conservative side of the court about what America is all about today and what's going on out there. Those differences very much in evidence in the writings of the Supreme Court, the things they said to us this past week. And second, equally troubling, as we go forward with these cases, fundamental disagreements about what our Constitution means in the midst of a nation, the content, the substance, the demeanor of which is not in agreement either. A difference about what the 14th Amendment means. What does equal protection means? We're going to talk about that. Some fairly virulent dissents condemning the decisions by the majority here in these areas and illustrating once again that the Supreme Court has a schism, if you will, in connection with understanding what the 14th Amendment is all about. Let's talk first about the Affirmative Action Program. This is the second case issued by the Supreme Court just on Thursday of this week. This decision rejected the affirmative action programs at colleges and universities around the nation, declaring that race-conscious admissions programs, in particular the defendants, so-called, in this case, Harvard, a private college, and the University of North Carolina, a public institution, were unlawful. They acted unlawfully, unconstitutionally, and therefore sharply curtailing here a policy that had long been a part of the pillars of higher education, and that policy was and is based upon past Supreme Court precedent, which we'll talk about, that admissions officials, admissions councils, the people who decide on who is coming into an incoming class, could in fact properly consider race as one of many factors, not the exclusive factor, but one of many factors to be considered by an admissions council in determining who gets in and who doesn't. The vote in this case just this past week was 6-3 to turn that policy, that practice back. The Chief Justice, John Roberts, wrote the opinion for the majority. He said this. He said, the Harvard and UNC admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause, once again calling into question and raising the ire, if you will, of the three so-called liberals on the bench about the interpretation of that clause. The Chief Justice wanted to say this. Both programs of both of these universities, both colleges, lack sufficiently focused and measurable objectives warranting the use of race. Objective factors, measurable objectives, insufficiently focused, he said, and therefore unavoidably employing race in a negative manner, involving racial stereotyping and lacking meaningful endpoints. That's kind of at the core of his decision in this case. Justice Sonia Sotomayor, one of the three dissenting justices in this case, we're going to hear more of her words in particular, summarized her dissent from the bench, which again is a rare move, signals profound disagreement, as I've indicated a couple of times already, said that affirmative action was crucial to countering persistent and systemic racial discrimination. That was the reason for the cases being decided as they were in the past. That is the tradition of America for the past 40 years. And that's what all of the universities, both those identified in this litigation and many others who had voiced their concerns about the change in this affirmative action regime, if you will, had articulated, which is that under Brown versus Board of Education, way back in 1954, what did our Supreme Court say? It said that there's something good, there's something very right, something very decent about sitting in a classroom. Sometimes it's also remote, but sitting in a classroom where the people who are surrounding you, your teacher, your professor, but certainly your fellow students, do not look exactly like you, have different experiences, not only in terms of their faith, their racial heritage, their national heritage, their background, their economic status, their sexual orientation, their gender identity, their abilities and disabilities, all those kinds of immutable characteristics that are protected by our Constitution and by statutes in this nation. All those things are promoted. Diversity is a good thing. Promoting education by having a diverse population, that's what the universities had argued in opposition to changing the standard for affirmative action in this nation. Sonia Sotomayor went on to say, the court today subverts the constitutional guarantee of equal protection by further entrenching racial inequality in education. She says it's the very foundation of our democratic government and pluralistic society. Expected, of course, that this sets off a scramble, probably underway for many months, perhaps anticipating this dramatic ruling, among schools, university colleges throughout the nation. Having to revisit their admission practices could complicate diversity efforts elsewhere, probably narrowing, at least for a time, if not indefinitely, the pipeline of highly credentialed minority candidates and making it harder for employers to consider race potentially in hiring as well. In a public televised address just hours after this major decision was handed down, President Biden assailed that ruling as a huge step backwards, very much in line with what the dissenters, the three dissenters said. He said this. He said, discrimination still exists in America. Today's decision does not change that, and promised that this decision was not the last word on affirmative action. An interesting statement for our president to make. Significantly, in her dissent, Justice Sotomayor wrote that the majority had abandoned principled adjudication as well. She wrote this. She said at bottom, the 6 unelected members of today's majority, that is the 6 members who are writing the majority opinion, she said, upend the status quo based on their policy preferences about what race in America should be like. But it is not. And their preferences for a veneer of colorblindness in a society where race has always mattered and continues to matter, in fact, and in law. That's what Sonia Sotomayor said, again, underscoring this fundamental difference about who we are in America, a difference inside our Supreme Court about the very Constitution with a small c, of what our communities of like are and what the diversity of America should be all about. When we come back, I'm going to talk with you more about what the Chief Justice said, the majority said, what the minority said as well, and about why this case is so very important, not just to our universities, but more broadly to the future of our republic. Stay with us for that discussion. We are continuing in this hour and also the next hour to discuss the United States Supreme Court right now talking about this major decision of just a couple of days ago, finding that affirmative action programs at Harvard and UNC and all other universities and colleges around our nation no longer valid under the Constitution, at least as we have known them. Right before the break, giving you some sense of the strong, profound disagreement among members of our Supreme Court. 6 of our conservative justices voicing support and endorsing this notion that affirmative action is no longer necessary in the nation in which we live. 3 members of the Supreme Court, including Sonia Sotomayor and Elena Kagan and Ketanji Brown Jackson, taking very, very strong objection to that and talking this morning about the things that both sides have said. Chief Justice John Roberts, again, writing for the majority in support of this invalidation of the affirmative action program, said that applicants must be assessed individually. In other words, he said the student must be treated based on his or her experiences as an individual, not on the basis of race. Now, interestingly, he said this as well. Two footnotes to this otherwise very strident statement about what we need to do in America to ensure diversity. I would offer not just in academic settings, but also beyond that. He said nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. Significant footnote and a significant condition on all this, plainly contemplating that universities can still request that students provide essays, which they certainly will, and in those essays could plainly self-identify based upon, as the Supreme Court said, inspiration and discrimination experiences in those areas. Also indicated along the way later in the opinion, curiously, without a whole lot of exposition, that the military academies might also be able to take account of race in their admissions decisions, as they have, as he said, potentially distinct interests. We don't know exactly what that means, but he's drawing a distinction, obviously, between the military academies that we know well in our nation and all other universities. We'll have to see exactly what that means. But the Supreme Court, again, giving a little bit of hope, if you will, to universities and colleges throughout the country with respect to essays, plainly interviews, those kinds of things, and presumably all the other things that can be done in terms of identifying and trying to establish what the universities universally have wanted in America, which is diverse populations on their campuses as a way of doing what? Promoting education. promoting understanding among the population that is in fact diverse and is not a reflection of just a very narrow view of America. Justice Sonia Sotomayor, once again saying that these exceptions, if you will, are fairly thin. She says, this supposed recognition that universities can, in some situations, consider race in application essays is nothing but an attempt, here we go, to put lipstick on a pig. That's what she wrote. That's what she said from the bench this past week. She acknowledged the majority had left colleges and universities with some tools, they're out there, to admit students of different backgrounds, mostly notably in socioeconomic factors, again, giving some consideration to financial issues as well. The Chief Justice wrote that educational diversity, he said, that idea that students of different backgrounds learn from one another is a commendable goal. That's good to hear, I suppose, from the Chief Justice. But he also added that such a goal resists the demanding judicial scrutiny that is required when race is a factor because it cannot be measured. That from our Supreme Court Chief Justice. Again, in dissent, Sonia Sotomayor writes that effectively the majority has jettisoned the rationale that had justified affirmative action for decades. And indeed, that is, in fact, the case. 200 pages of majority opinions and minority opinions here. Clarence Thomas, Sam Alito, Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett join the Chief Justice's majority opinion. And, of course, Elena Kagan and Ketanji Brown Jackson joined Justice Sotomayor in her strong dissent in all of this. Significant that only from the bench when this was argued way back in the fall of last year, but a strong disagreement between a fellow named Clarence Thomas and Ketanji Brown Jackson from the bench. Clarence Thomas writes a 58-page concurring opinion, and drawing on his own experience as a black man, he mounted what he called a defense of the colorblind Constitution. In order to clarify, he said that all forms of discrimination based on race, including so-called affirmative action, are prohibited under the Constitution. His remarks, both again from the bench way back in the fall and again written and announced just this past week, get a strong sense of resistance from the minority members of our Supreme Court, inside and outside. Justice Ketanji Brown Jackson, along with Thomas, one of only 3 black justices who ever served on the court, responded again bitterly to what she is hearing from her conservative colleagues. She says this, with let them eat cake obliviousness today, the majority pulls the ripcord and announces colorblindness for all by legal fiat. But deeming race irrelevant in law does not make it so in life. She argued that for many Americans, race permeates their lived experience daily. The best that can be said of the majority's perspective, she went on to say, is that it proceeds ostrich-like, that is, putting your head in the sand, from the hope that preventing consideration of race will end racism. The approach embraced by the court in Chief Justice John Roberts' majority opinion on Thursday has been a long-term goal, plainly, of the conservative legal activists. This has been out there for a long period of time, not entirely unexpected, not only in the wake of the oral argument of last fall, but also for many, many years previous to this. We know as well, again, as I said, that this is a significant change in the law that's been announced and has been effective for about 40 years. The two cases from UNC and Harvard derive from Title VI of the Civil Rights Act and also equal protection of the 14th Amendment. The North Carolina case, plaintiffs have said that the university discriminated against white and Asian applicants by giving preference to black, Hispanic, and Native American ones. The university, again, has responded by saying that its admissions policies fostered exactly the kind of educational diversity that I'm describing this morning and were lawful under long-standing positions of the United States Supreme Court. That key precedent way back in 2003, announced by Sandra Day O'Connor, one of the conservative justices. The case was called Grutter versus Bollinger, in which the Supreme Court said that holistic admissions programs permitting race to be considered for the purposes of educational diversity are appropriate and endorsed and constitutional. That was Sandra Day O'Connor and a majority of our Supreme Court in 2003, not that long ago. Significantly, Sandra Day O'Connor said that it may well come that in a day, maybe about 25 years from now, or in 2028, she said the use of racial preference will no longer be necessary. Well, the Supreme Court advanced that a few years Justice John Roberts said there's no reason to believe that respondents will, even acting in good faith, comply anytime soon. That day has come, and it came in America just this past week. Stay with us for this second hour of Morning Cannolis. We're going to talk more about this admissions case and then also about the other two major cases of this past week, this past term, right here on our morning discussion of America and the law by which we are governed.
I ain't no millionaire son, no, no. It ain't me, it ain't me. I ain't no fortunate one,
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Thank you for once again joining me for this, our second hour on the first day of July 2023. Going into the 4th of July observance, the celebration of our nation at a sobering time in America as we talk about at least three major decisions of our United States Supreme Court of this past week that are already changing who we are, not only in terms of our operations in and outside of classrooms, but employment settings, and fundamentally redefining the community in which we live. Reasons for great concern as we go forward into this 4th of July holiday. We're talking right now about this decision of just this past Thursday in which the Supreme Court rejected about 40 years of affirmative action policy and programs and protocols for universities and colleges around our nation. Giving you this morning some dramatic readings, if you will, from some of the things that the Supreme Court justices have said to underscore my two major theses. One is that we have in the Supreme Court today a fundamental schism between what some members of the Supreme Court think America is all about and what others believe it's all about. That comes through loudly and clearly not only in this opinion and in the dissenting opinions in the affirmative action case, but also in the other cases we're going to talk about this hour, including the rejection of President Biden's student loan forgiveness plan, and finally in the last portion of this hour, Supreme Court rejecting the position of the state of Colorado that would require that a business provider there who's providing website services to couples who are getting married, that she not engage in discriminatory statements and conduct, especially with respect to same-sex couples. We're going to get to that as well. Again, this fundamental schism not only about who we are as a nation, but also what our Constitution and the statutes and laws that have been enacted under it require of all of us. Ketanji Brown Jackson virulently opposing what happened here in this affirmative action case says this: the court has come to rest on the bottom line conclusion that racial diversity in higher education is only worth potentially preserving insofar as it might be needed to prepare Black Americans and other underrepresented minorities for success in the bunker, not the boardroom. A particularly awkward place to land in light of the history the majority opts to ignore. She goes on to say it would be deeply unfortunate if the Equal Protection Clause actually demanded this perverse, ahistorical, and counterproductive outcome. To impose this result in that clause's name when it requires no such thing, she says, and is therefore to obstruct our collective progress toward the full realization of the clause's promise. That's truly a tragedy for us all, she writes. Justice Roberts comes back. Again, they're plainly responding to each other, even as they're announcing their opinions in writing and in orally. He says, most troubling of all is what the dissent must make these admissions to defend. A judiciary that picks winners and losers, he says, based on the color of their skin. While the dissent would certainly not permit university programs that discriminated against Black and Latino applicants, it is perfectly willing to let the programs here continue. In its view, that is the dissent view, this court is supposed to tell state actors when they have picked the right races to benefit. And Sonia Sotomayor comes back. She says, notwithstanding this court's actions, however, society's progress toward equality cannot be permanently halted. Here's the commission for the future. This is what we do. Sonia Sotomayor gives us that roadmap. She says, diversity is now a fundamental American value, housed in our varied and multicultural American community that only continues to grow. The pursuit of racial diversity will go on, she says. Although the court has stripped out almost all uses of race in college admissions, universities can and should continue to use all available tools to meet society's needs for diversity in education. Despite the court's unjustified exercise of power, she says, the opinion today will serve only to highlight the court's own impotence in the face of an America whose cries for equality resound. What commanding language. And there is a commission for you from one of the dissenters, Sonia Sotomayor, certainly joined in by Ketanji Brown Jackson and Elena Kagan in strong opposition to what our Supreme Court has done in this case involving affirmative action just 2 days or so ago. We will see how this plays out at universities around our nation. The great concern is whether or not we will continue to move toward campuses, both in classroom and out of classroom, that are diverse for the benefit of education, of understanding, and of learning. And that is our summary this morning of the affirmative action case. We've got a couple of callers who have called in and dutifully waiting. Let's hear from them at this time. Joe, let's start with you in Madison. Glad to have you with me again this morning. Joe, your thoughts, comments, questions, or observations?
I'd like you to offer some observations on this. The thought is race had been considered at many schools, okay, for diversity. Well, in many schools, legacy admissions are considered.
Yes.
And the rate is very, very high. And Harvard is a very good one to look at. One of the plaintiffs, I guess, in this particular situation, because as I understand in Harvard, their 2021 class, 29% of that freshman class were people who were accepted, where legacy was part of the acceptance package for them. So, if you will, it was affirmative action for the rich. Excuse me while I fire up my Fury mobile here, but there's something that I was never able to take advantage of, or many people aren't able to take advantage of. So if we want to have a diverse population, how does legacy admission help at all to create a diverse population? How does legacy admission help any social good at all? I would think, and I'd be interested in your reactions to that there ought to be some lawsuits coming fast and furious that just because your dad went to this school, why do you get preference in going to this school? Why would that possibly exist? How would that make a difference? Particularly at public schools. I suppose at private, maybe they could still continue. But I just, if equal protection is the goal, what is served by legacy admission in terms of reaching that goal? I'm interested in your reactions to that. Thanks a lot, Jim.
And Joe, as always, profoundly insightful thoughts. And that's the part of the discussion that's going on right now in the wake of this, right? What are the consequences of this decision that talks about an America, yes, in connection with race, being colorblind, as Justice Thomas and others say, but the implications of that much broader, again, with respect to legacy. If, in fact, you're giving preference to people whose parents and other relatives have been members of the population, the student population before, isn't that also a preference that, at its core, is contrary to what the Supreme Court has said? I would endorse and answer in exactly the way that you packaged into your very question, Joe, which is that's exactly the kind of thing that this opinion has now opened up. What can a university do and what it cannot do, not only in the area of race, that's very, very important, but also more broadly. Legacy comes to the top of the list as a second, maybe a third consideration as well. Those lawsuits are now coming. And how does the Supreme Court then deal with that? Does it at some point down the road determine and impose upon colleges and universities, public and private both perhaps, an obligation not to consider legacy? Parental or other relatives who have been at these universities. Is that next? And if so, is that consistent with what we're hearing today? And if it's not consistent, Explain that incongruity, if you will. And so I think it's more than just a rhetorical question, Joe. It is the great one among others that this affirmative action case, this opinion today, underscores. The language of the dissenters is rife with those kinds of inequality types of considerations, and plainly will animate those lawsuits, which I think are still coming. Thanks so much for the call, Joe. Is always insightful, and we'll continue to think about those questions down the road. Mark, also calling in this morning. Glad to have you with us, Mark, on this and other issues before our Supreme Court these days.
Yeah, thanks, Jim, and thanks to Jo. She's always very concise in what she says. What I find somewhat bemusing is, once again, as I've pointed out in the past, is the failure of the Supreme Court to acknowledge the fact that it is not enumerated in the Constitution that they had the power at all to decide the constitutionality of laws. In fact, as I pointed out before in Federalist 81, that Hamilton warns against, he says, one of the concerns about the Constitution is people are concerned about the Supreme Court seizing the power actually that they're exerting here and deciding the constitutionality of laws, because he says in part of 81 that it's both unprecedented and dangerous for them, for the court to be able to do this, have this power. And in fact, if race is not a problem anymore, it was like they're saying, it doesn't exist. Then why do we need the 15th Amendment, which says we can't discriminate on the basis of people cannot be denied rights on the basis of color? And they've denied the government ability to do things because it's not enumerated in the Constitution. When in fact, that Madison points out in Federalist 44, I believe, that we don't know what every possible contingency Congress might be called upon to address the nation's problems, that because that would just be you couldn't do it.
Right.
So it's included within the General Welfare Clause that they have the power to promote the general welfare, and I would say promoting diversity is part of the general welfare.
Absolutely.
It's become part of the general welfare,
Right.
Because let's remember that in the Taney decision, the Dred Scott decision, it's actually more horrible than most of us were taught in high school. The Judge Taney actually said that the black he didn't even call them citizens. He would call them citizens. He barely could call them persons. They had no right to for anything at all because of the color of the skin.
Lots of things there, Mark, to unpack. Absolutely, historically, and I'm just going to seize upon the one with respect to the amendments, the reason for the implementation, the passage of those amendments post-Civil War, 14th, 15th Amendments, remedy exactly the kinds of things you're talking about, and an interpretation this week, I think you're offering and others offering, that is contrary to that fundamental notion about what the purpose of the 14th Amendment is all about, equal protection of the laws. Many, many good things there, Mark, to unpack and to think about. Appreciate those comments as well. And Mark, as we're going into a break, will also indicate that in the coming hour here, we're going to chat more about this case and also about the other two cases with respect to student loan forgiveness and also the web designer coming out of the state of Colorado. Let's begin to chat about that matter as well. That is the decision by the United States Supreme Court to reject the president's student loan forgiveness plan, again, fairly decisively in language that is also going to be a part of our discussion this morning. Stay with us for that discussion. Also taking more callers after this break on a very important broadcast here on this Saturday morning as we go into the 4th of July holiday. We are back this morning talking about all things Supreme Court, a major week in the history of the Supreme Court and indeed of our entire nation, talking this morning about this case involving accommodations for religious workers, a 9-0 opinion. just before the break and in the previous hour, then talking about the decision by the Supreme Court, a majority, 6-3 majority, rejecting the affirmative action programs at Harvard, UNC, having a dramatic impact upon universities and colleges throughout our nation. Some great calls as well, some great observations about the implications of those orders coming out from listeners. We're talking to more of our listeners in this hour as well. Turning now to the third case in the docket among many decided by the Supreme Court this past term. Supreme Court rejecting the president's student loan forgiveness plan. The Supreme Court in particular just yesterday telling the Biden administration that it has overstepped its authority with its plan to wipe out about $400 billion in student debt. And that, of course, undermining, even dashing the hopes of millions of borrowers around the country and imposing some very unsettling but not necessarily new restrictions from this court on presidential power. Resounding setback, undeniably, for President Biden, the executive branch more generally. He had vowed to help borrowers, as he said, crawl out from under that mountain of debt. The statistics as part of the litigation before the Supreme Court show that more than 45 million people across the country owe about $1.6 trillion in federal loans for college, and that this proposed debt cancellation, which was announced by the president last summer, about a year or so ago, would have been one of the most expensive executive actions in U.S. history, but also an awful lot of predictions about the benefits coming not just to our economy, but also to people generally in our nation. This case, again, a part of a tumultuous term, now not actually done, but the major decisions now done, kind of a trifecta of some major cases. Again, we talked about one of them. That is the affirmative action case, this student loan forgiveness program, and then in our final moments of this hour, talking again about this major blow to gay rights, LGBT rights, accomplished with respect to another decision made by the Supreme Court. The president said today's decision has closed one path, but he promised to pursue some others. He was talking yesterday about the Higher Education Act, summoning his Secretary of Education in to identify new ways of accomplishing some things that the United States Supreme Court has now foreclosed to him and to the executive branch generally and to all of us. So what is this case all about? Well, Chief Justice John Roberts, again, he's writing for the majority in a major decision that is reverberating from other things that he has said about the authority of the executive, the limited authority of the executive to act on behalf of Americans. He writes, he says that a 2000 law, which had allowed the Secretary of Education to waive or modify, that's the language of the statute, that language, those relevant statutes, those regulations, that you can do that in emergencies, had not authorized this administration, the Biden administration, the present Secretary of Education, to cancel the debt. He made the different distinction between modifying, waiving, and completely transforming was the word he used, and that was too far. He said the Secretary's plan has modified the cited provisions and went on to say, only in the same sense that the French Revolution modified the status of the French nobility. It has abolished them and supplanted them with a new regime entirely. That's the Supreme Court Justice, the Chief Justice, writing about what the executive has done here. Needless to say, the three dissenters on the Supreme Court, you know their names well, bitterly, once again, strongly dissenting. Elena Kagan here is summarizing her dissent from the bench. Again, this rare move, we have not seen this before, virulent dissents from the bench, a sign of deep disagreement among this court, once again, about who we are as Americans, about what the law does and does not require. Siding with 6 Republican-led states that sued to block the program, she said, the majority opinion today is opportunistic, unprincipled, and infected by politics. Those are strong words coming from any Supreme Court justices. She goes on to say this, from the first page to the last, today's opinion departs from the demands of judicial restraint. And this is the basis upon which an awful lot of us thought these cases would not even be decided, a thing called standing. She goes on to say this, at the behest of a party that has suffered no injury, the majority decides a contested public policy issue properly belonging to the politically accountable branches and the people they represent. And again, underscoring this question about whether or not there is standing at all. There's a real damage by the people who brought this lawsuit against the president's plan, this program to forgive debt. Along the way, the cases themselves, coming from some 6 Republican-led states: Nebraska, Missouri, Arkansas, Iowa, Kansas, South Carolina. 2 individuals, all of them suing to stop the new plan. They had reached this decision, if you will, internal to their own litigation side of the House, that this plan is inconsistent with something called the Major Questions Doctrine. So a little civics this morning. Major Questions Doctrine. What does that basically say? Congress, it says, must speak particularly clearly when authorizing these kinds of things. A piece of doctrine that's not really articulated specifically, that language not used by the Supreme Court, basically says that the Supreme Court has rejected and can reject agency claims of authority, like here, when the underlying claim of authority concerns an issue of vast economic and political significance. When it's very big, when it's huge, when it's large, that's a part of it. And second, when Congress has not clearly empowered the agency with authority over the issue. That's something called the Major Questions Doctrine. And again, the people challenging the president's action here, his plan here to forgive this debt, used that policy to allege that this had overstepped the executive authority. The Major Questions Doctrine implicated here, too big, and too new, according to what the Supreme Court has said in the past in other cases. Last June, the court had used this particular doctrine, which it again invoked here, in a decision that curtailed the EPA in its power to address climate change, also ruled on civil grounds that the CDC was not authorized to impose a moratorium on evictions. Again, that happening in previous terms of this court. When we come back, I'm going to talk more about this Major Questions Doctrine, what the Chief Justice said, what the dissenters said, and again, why this case is important not only for debtors out there of student loans, but also for all of us. Stay with us for that discussion.
That likes to roam around. I'm never in one place. I roam from town to town, and when I find myself falling for some girl, yeah, I hop right into that car of mine. I drive around the world. Yeah, I'm a wanderer. Yeah, a wanderer. I roam around. I'm standing here outside your door. I hate to wake you up.
We are back talking this morning about the Supreme Court and now this major decision issued just yesterday, finding that the president's student loan forgiveness plan is unconstitutional as an overbroad expression and extension of executive authority. This thing called the Major Questions Doctrine, actually a phrase not used by the Supreme Court, but applied to explain when the Supreme Court says that the executive branch, the president, can act. And my interpretation, the accessible interpretation of that doctrine, basically the Chief Justice saying if it's too new, we haven't seen this before, and it's too broad, too big, too large economically or some other way, it cannot stand consistent with constitutional principles. And indeed, that's exactly the basis upon which Chief Justice John Roberts said that this loan forgiveness program must fall. He said that this is 10 times $519 billion estimate, 10 times the economic impact that we found significant in concluding that an eviction moratorium implemented by the CDC triggered analysis under the Major Questions Doctrine, amounts to nearly 1/3 of the government's $1.7 trillion in annual discretionary spending. No serious dispute, he says, that the Secretary claims the authority to exercise control over a significant portion of the American economy. That's what the Chief Justice writes in support of rejecting the president's plan here to forgive loans. Justice Kagan arguing that this 2000 law that we cited previously squarely and plainly authorizes the program. She says this: the statute provides the Secretary with broad authority to give emergency relief to student loan borrowers, including by altering usual discharge rules. What the Secretary did here, she says, fits comfortably within that delegation, but the court forbids him to proceed. As in other recent cases, the rules of the game change when Congress enacts broad delegations allowing agencies to take substantial regulatory measures. In other words, a real affirmation of the authority then of the executive branch to do exactly what its name says, which is to execute the law. Sam Alito, Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett joined the majority opinion, again authored by the Chief Justice. Dissent, Elena Kagan, also joined by Sonia Sotomayor. Ketanji Brown Jackson also issued a harsh critique of this major questions doctrine. She says the question the majority helpfully tells us is, who has the authority to make such significant calls? The answer, as is now becoming commonplace, is this court. Those are strong words coming from a Supreme Court justice. Key threshold issue, of course, as I indicated before, standing. An awful lot of people thought the Supreme Court was going to get rid of this case, dismiss it, based upon standing. When the case was argued in February, the justices seemed to focus on a nonprofit entity that services federal loans called the Missouri Higher Education Loan Authority. It was called MOHELA is the acronym for it. States argued that the entity's potential losses from the loan forgiveness program were so great, so significant, to confer standing on it, because it effectively ran an arm of the state of Missouri. They also said that the authority might fail to make payments to Missouri if the program were allowed to proceed. And Pierce at John Roberts embraced that theory. By law and function, he said, MOHELA is an instrumentality of Missouri. It was created by the state to further a public purpose, governed by state officials and state appointees. And that is the only basis upon which he finds standing. Very tenuous, not at all clear, circuitous at best, but nonetheless a basis for finding that the president's plan is not supported. The dissent, again, Justice Kagan says, in giving these states a forum in adjudicating their complaint, the court forgets its proper role. The court acts as though it is an arbiter of political and policy disputes rather than cases and controversies. Deciding this case, she wrote, blows through a constitutional guardrail intended to keep courts acting like courts. She scoffed at the loan services connection to the case, noting that it had not sued on its own behalf or was anyway incorporated into this lawsuit. She says this, is there a person in America who thinks that Missouri is here because it worried that MOHELA's loss of loan servicing fees was important? I would like to meet him, Elena Kagan says, and goes on to say there's nothing personal in the dispute here, but justices throughout history have raised the alarm when the court has overreached, adding that the alarm was warranted right now. In a case, not a case, she writes, this is Kagan, the majority overwrites the combined judgment of the legislative and executive branches with the consequences of eliminating loan forgiveness for 43 million Americans. The consequences are huge. This is very significant. Again, the president indicating through the Higher Education Act that he'll pursue other means of doing what the Supreme Court has prevented him from doing. Great dissent, great disagreement among our court, not only about what this particular statute from a number of years ago permits the secretary to do, but also about the decisions among the branches of government, how those decisions are made, and allocations of authority that Congress passes the law, and the president then is responsible for executing it through his cabinet, including the Secretary of Education. Strong disagreement here. And so further articulation, however, of the Supreme Court's view of a very limited government and certainly a very limited executive branch, not given the capacity, even with clear statutory authority, seemingly to do what it should do in furtherance of good things here in America. Tom, you've been waiting on the line for a while. We'll take your call now, your observation or question about any of this.
Hi there. I apologize. I'm putting the cart before the horse here because you haven't spoken of it really. The whole website case.
Getting to that right now, Tom. Good. Go ahead.
My question is, where is the line drawn between being able to discriminate against these people and serving people at a lunch counter, whether it be color or sexuality or whatever? Where is that line drawn now to refuse service? Right.
That is, Tom, thank you so much for that, not just rhetorical question. That is the question of the day, right? Once again, the rule of all of these cases is opening up doors and raising more questions than they answer. And let's talk, Tom, at your very timely invitation about this fourth major case decided by the Supreme Court just this past week. This one, no less troubling than all the other, at least the other two cases that we have talked about this morning. The justices settling a question that was left open in 2008, in other words, whether businesses open to the public and engage in expression may refuse to serve customers based on religious convictions. That's kind of the way that the Supreme Court had styled this case. We'll talk more about that. Deciding just yesterday, as Tom just said, that a web designer in Colorado, the state of Colorado, who said she had a First Amendment right to refuse to design wedding websites for same-sex couples, despite a state law, again, not a federal law, but a state law here that forbids discrimination against gay people. Neil Gorsuch writes the majority opinion here, which is especially surprising. Let me pause here and talk about Neil Gorsuch for just a moment. Neil Gorsuch was the one who a number of years ago wrote this case in Bostock that said that the word sex, as it appears in Title VII of the Civil Rights Act, does in fact provide coverage for the LGBTQ plus community. It basically does include sexual orientation, gender identity in the employment setting, prohibits discrimination, terms and conditions of employment, hiring, firing, all the other things when it comes to employment under Title VII. So when I saw yesterday morning that Neil Gorsuch was writing the opinion in this case, my initial reaction was, this is a good thing. Neil Gorsuch will be once again articulating an affirmation of the position not only of our LGBT community in our nation, but the right to everyone, consistent with Tom's question, to be served at the lunch counter, to have access to commerce. Hugely disappointed. Neil Gorsuch, writing for the majority, a 6-3 majority once again, right down ideological lines, saying the First Amendment protected the designer, her name is Lori Smith, from being compelled to express views she opposed. Again, all of this a creature in very many ways of the Supreme Court's identification of the way this case was presented. The court says this: 100 years ago, Ms. Smith might have furnished her services using pen and paper. Those services are no less protected today because they are conveyed with a voice that resonates farther than it could from any soapbox. This case, again, framed as a clash between free speech and gay rights, nonetheless the latest in this series of decisions in favor of religious people, one of which we saw earlier today, probably a good decision, and notably some conservative Christians out there. The decision also appears to suggest, once again, with not explicit statement, but nonetheless sending this message to America, that the rights of LGBT people, including those in same-sex marriages, are on a more vulnerable legal footing than they were a day ago, particularly when they are at odds with claims of religious freedom. At the same time, the ruling appears to limit the ability of governments to enforce anti-discrimination laws, a great concern here. Again, the justices on this case, like the other two that we've discussed this morning, splitting right along ideological lines. In many ways, as I read these opinions, talking past each other. The majority saying that they're safeguarding First Amendment rights, the artists to express themselves in America. Liberal justices viewing it as something else entirely, a dispute that threatens societal protections for gay rights and rolled back some recent progress. And once again, we're going to read again from some of the dissents here, an impassioned dissent, once again from Sonia Sotomayor. She is angry. She is angry in a professional way, but nonetheless angry and concerned about America. She says that the outcome signaled a return to a time when people of color and other minority groups faced open discrimination. Tom, just as you said in your question about people being served at the lunch counter. The second time this week, once again, that she, along with Elena Kagan and Ketanji Brown Jackson, articulate this rare disagreement from the bench itself. She spoke for more than 20 minutes. She said this case cannot be understood outside of the context in which it arises. In that context, Sonia Sotomayor says, the outcome is even more distressing. The LGBT rights movement has made historical strides, and I am proud of the role this court recently played in that history. However, today we're taking a step backward. The president also said that he finds this decision, like the other we've talked about, disappointing. In a statement that he released on Friday, he says this: I'm deeply concerned the decision could invite more discrimination against the LGBTQIA plus Americans. More broadly, today's decision weakens long-standing laws that protect all Americans against discrimination in public accommodations, including people of color, people with disabilities, and people of faith and women. And indeed, we'll recall well the history of this court, that Sonia Sotomayor talks about when she describes this notion of the Supreme Court in the past, in a case called Windsor, another case called Obergefell, has affirmed the rights, the privacy rights to engage in same-sex marriage, finding that the Defense of Marriage Act, defining marriages between a man and a woman as being unconstitutional, and then going ahead in a subsequent case a couple of years later, Justice Anthony Kennedy, in this lofty decision about the rights of all human beings, the rights of all citizens to enjoy the liberties that we celebrate this very weekend, including the right to marry who you love, who you want to affiliate with for the rest of your life. Those are also traditions of the Supreme Court, not overruled by this decision yesterday, but coming in the wake of those greatly affirming decisions, a source of great concern, again, as articulated by the president and certainly by the dissenters in this. The Colorado law upon which this case is premised forbids discrimination against gay people by businesses open to public as well as statements announcing such discrimination. In other words, not only can you not discriminate based upon that immutable characteristic and others protected by the law, but you also can't announce that discrimination. And Ms. Smith, again, the plaintiff in this matter, this is very, very interesting in terms of the procedural status of this case, said that her Christian faith requires her to turn away same-sex couples seeking website design services that she would otherwise offer. Interestingly, she had not yet begun to provide those wedding services, nor had she posted a proposed statement on her current website declaring her policies or beliefs. She said she didn't do that because out of fear. She said she was running afoul of the law, and she sued to challenge that law, saying that it violated her rights to free speech and the free exercise of religion. Colorado's Attorney General had said that the implications of the ruling yesterday could pave the way for all sorts of businesses to turn away LGBTQ customers. We're going to talk about the implications of that, things that Colorado Attorney General said in our final segment coming up this morning, and also taking more callers about this all-important decision from a United States Supreme Court just yesterday. Stay tuned for that conversation.
Oh, babe, I hate to go. I'm leaving on a jet plane. Don't know when I'll be back again. Oh, babe, I hate to go.
And we are back in this final segment of our program this morning, talking about this major case, the fourth major case we're discussing this morning, in which the Supreme Court sided in favor of a website designer in Colorado who's opposed to same-sex marriage. Majority opinion written by Neil Gorsuch, and again, in the interest, as we have all this morning, providing information about what both sides have said. Neil Gorsuch, writing for the majority, says the government could not force people who speak for pay on a given topic to accept commissions on that topic in cases where they disagree with the underlying message. Gorsuch goes on to say such an approach, he said, could lead to bizarre results. He cited the example of a Muslim movie director being forced to make a film with a Zionist message, or an atheist being forced to accept a commission to create a mural celebrating evangelical zeal. Went on to say, taken seriously, that principle would allow the government to force all manner of artists, speechwriters, and others whose services involve speech to speak what they do not believe on pain of penalty. Countless other creative professionals, too, he said, could be forced to choose between remaining silent, producing speech that violates their beliefs, or speaking their minds and incurring sanctions for doing so. He adds that states could not use public accommodations laws to deny speakers the right to choose the content of their messages. Otherwise, the justice wrote, the better the artist, the finer the writer, the more unique his talent, the more easily his voice could be conscripted to disseminate the government's preferred messages. That would not respect the First Amendment. More nearly, it would spell its demise. Again, the Supreme Court majority articulating this strong affirmation of the First Amendment and describing its opinion, contrary to what the dissent describes as being a First Amendment position. In dissent, once again, Justice Sonia Sotomayor describes public accommodation laws as designed to ensure equal dignity in the common market, a very common and important notion. She cites a 1964 Supreme Court case called Heart of Atlanta Motel versus United States, where the court found that hotels did not have the right to discriminate against black guests. Goes on to say this is Sonia Sotomayor, if you've ever taken advantage of a public business without being denied service because of who you are, then you have come to enjoy the dignity and freedom that this principle protects. Lesbian, gay, bisexual, and transgendered people, no less than anyone else, deserves that dignity and freedom. Justice Gorsuch responded directly to that and says that the two sides looked at the same case and saw totally different issues. Again, consistent with my view this morning that we've got a Supreme Court that's wildly disaffected on both sides with respect to who America is, what we're all about, what the law says. He goes on to say, it's difficult to read the dissent and conclude that we are looking at the same case. The dissenting justices, he wrote, focused on the strides gay Americans have made towards securing equal justice on the law. The conservative justices do not see the case through that lens. He says, writing that none of this answers the question we face today. Can a state force someone who provides his own expressive services to abandon her conscience and speak its preferred message instead? We've got a lot of opinions to read through here. Divided three-judge panel for the 10th Circuit applied the most demanding form of scrutiny in the court below and upheld the Colorado law. Significantly along the way in this case, there was also disagreement about the implications of George Orwell's statements, believe it or not. In the course of the lower court opinion, in a dissent in that case, the Chief Judge Timothy Timkovich had cited George Orwell, said the majority takes the remarkable and novel stance that the government may force Ms. Smith to produce messages that violate her conscience. And that approach seemed to resonate, if you will, with Justice Gorsuch. He said the language of George Orwell is relevant. He wrote, the court's liberal justices have abandoned what this court's case have recognized time and time again. A commitment to speech for only some messages and some persons is no commitment at all. He adds, citing Orwell's speech he gave called The Freedom of the Press, he says that if liberty means anything at all, it means the right to tell people what they do not want to hear. Justice Sonia Sotomayor said in her dissent, the conservative justice has completely misread this issue. Goes on to say this, the majority's repeated invocation of this Orwellian thought policing is revealing just how much of it misunderstands this case and goes on to talk about the impact that this will have upon Americans generally inside the LGBT community and beyond. Among the other things that she describes, these kinds of things. She says the majority is simply wrong, profoundly wrong. The law in question targets conduct, not speech, for regulation. She underscores this notion the Supreme Court is purposely describing this case in a way that doesn't get to the real issue. She goes on to say, and then the act of discrimination has never constituted protected expression under the First Amendment. Our Constitution, Sonia Sotomayor says, contains no right to refuse service to a disfavored group, and for that reason, I dissent. She goes on to say this, the state may ensure that groups historically marked for second-class status are not denied goods or services on equal terms. The concept of a public accommodation laws, which is what this case is all about, thus embodies a single, simple, but powerful social contract. A business that chooses to sell to the public assumes a duty, she says, to serve the public without unjust discrimination, rejecting both this First Amendment cast that the majority, 6 members of it, embrace and describe as the basis for supporting the website designer over the Colorado law. And in final commission, Justice Sonia Sotomayor goes on to say this about what this license to discriminate is what she describes this opinion as being all about. She asked what it means to a family with same-sex parents to see a notice that reads, some services may be denied to same-sex couples. She says it reminds LGBT people of a painful feeling that they know all too well, kind of reminiscent of what Justice Kennedy had said many years ago in his opinions. She said they are not some public places. There are some public places where they can be themselves and some where they cannot. Ask any LGBT person, Sonia Sotomayor says, and you will learn just how they are forced to navigate life in this way. They must ask themselves, if I reveal my identity to this coworker or to this shopkeeper, will they treat me the same way? If I hold the hand of my partner in this setting, will someone stare at me, harass me, or even hurt me? It is an awful way to live. That's from our Supreme Court in dissent. That's Sonia Sotomayor, and I should indicate as well that the other liberal justices, Elena Kagan, Ketanji Brown Jackson, also describing a different America, which is the theme of much of our discussion this morning, describing a law that they view as very differently, the Constitution a very different law as well. What do you take away from this case and the others? Well, plainly, the Supreme Court today, even in its description of this as being a First Amendment principled decision, has nonetheless turned the clock back. And we will see how this plays out. The specter of this being used to promote LGBT discrimination is out there and greatly concerning. On this program, we will continue to entertain voices from all aspects, acknowledging that reasonable people can disagree on things that are reasonably disagreed on. Some things, however, in our Constitution, others are not. We'll talk about more of those next week as we consider again more Supreme Court cases coming out of this term. Stay with us for that next discussion coming up next Saturday here on Morning Cannolis. Thank you for joining me this morning.
But when the shadowy sun sets on the one that fires